And yeah, the last speaker of our first panel is Dr. or PhD Xiayu Shi. She completed her dissertation in China, and she's currently a postgraduate student at the Case Western Reserve University or in the US. And she's working at the Southwest University of Political Science and Law in Chongqing in China, and is currently a visiting researcher at our chair of Professor Dr. Christian Tietje. Yeah, very welcome here in Halle, and we're looking forward to your presentation.
Okay, good afternoon, distinguished professors, guests, and friends. Thank you very much for giving me this opportunity to present my paper at this Young European Law Scholars Conference. And my paper examines European Union's anti-coercion instrument, the ACI, as a legal response to economic weaponization. And here I will just show you this introductory remarks, because this ACI instrument entered into a forced adult moment when economic security has been one of the EU's concerns. The background is the growing use of economic pressure in international relations. As we can recall, the China-Lithuanian disputes, the Russians' energy pressure, and early US tariff threats over France's digital service tax, they all resemble this kind of similar structural problem. And even in early 2026, the EU has been urged to consider the using of this unused instrument as a response measures to tariff threats by US presence over the Greenland. Can say from here. Okay, sorry. I mistakenly attached something on this screen. Okay. But it's okay. Can you guys see this? Can you help me with this? Sorry. I'm sorry for this one.
Next slide.
No, this one.
Okay.
Thank you. And so, some European officials characterize this kind of tariff threats like as a potentially coercive threats or use of tariff against European members. So the guiding problem right now is the international law lacks a general threshold for economic coercion. And so states increasingly use market access financial markets, like export controls, investment screening, technology checkpoints, and supply chain dependence to influence another state's sovereign choice. So we can see the ACI is therefore best understood as a response to weaponized interdependence, which is the use of economic dependence to shape another state's legally protected choice. And yet, international law does not offer a single and very settled threshold for economic coercion, and ACI is situated in this international gray area. And here I want to propose for my main questions for my paper. So where do the legitimacy boundaries of unilateral counter instruments such as ACI lie? I don't want to analyze from a simple lawful or unlawful binary. Instead, I use from this perspective a continuum of legitimacy tied to the strict doctrine of countermeasures. In this paper, I will mainly analyze the countermeasures from the International Law Commission's draft articles on the responsibility of states for internationally wrongful acts. Later on, I will just refer to ASEVA. And here I make 3 analytical moves. And first one, I will examine the EU's institutional design. And the second one, I will identify economic coercion as a functional threshold. And third one, I will test each union response under international law, mainly is under the ASEVA. Okay, now we can see from here is the ACI institutional move. It's from shielding to deterrence. As we can say from the timeline, in 1996, the European Union has already adopted the blocking regulations as a shielding to the US extraterritoriality legal frameworks. And here we can see 2021, ACI has been proposed, and right in 2023, it has been entered into force. But in the future use, we have to, make a very thoughtful consideration about how to discipline the response from the EU side. And from the ACI's Article 1 or Point 2, we can see it's very clearly that the ACI is designed to deterrence, not for retaliation. And here in its legal design, the dialogue and negotiation comes first. The union response measures are supposed to be adopted as a last resort. So this sequencing matters because ACI is meant just for to bring the coercing state back to the legal path, not for retaliation. And also the Article 8 of ACI provide a very broad response options, such as tariff measures, procurement measures, investment restrictions, service restrictions, intellectual property measures, and financial service measures. And it covers with a lot of it covers with very broad option. This broad option really gives the ACI more deterrent value. At the same time, it creates some central risk. And this risk, I will talk more in how it shows in its attempt to institutionalize a collective response to coercion. And here we can see the ACI is situated and with its legal basis in Article 207 of the Treaty on the Functioning of the European Union with Common Commercial Policy. So this choice actually is constitutionally very significant. It means that the Union addresses a geopolitical phenomenon into a legal architecture of, with supranational architecture of trade law, rather than only through the common foreign security policy. It also matters because coercion may target one member state while operating through trade or investment channels that may affect the Union as a whole. And it is very persuasive if that coercion targets against one member state may, depending on its design and the effects, threaten the internal market of the European Union or weaken the credibility of the common commercial policy, or even impair the Union's capacity to protect the member state autonomy. In that sense, the ACI transforms a national pressure point into a union-level legal concern. So this institutional transformation also requires a more precise method of legal assessment. So later on, I'm going to examine more on economic coercion side. As we can see from this slide, economic coercion is just a gateway concept. It does not itself as complete as a legal justification. Because pressure alone is not illegality, international relations often involve with a lot of pressures and bargaining power and competition too. Sometimes the state may withdraw a voluntary tariff, a voluntary benefit, adjust market access without committing an internationally wrongful act. The legal concern is therefore more specific. So whether a state is being forced to give up a choice protected by international law, that is the point I said is the surrender of a legally protected choice. In similar terms, economic coercion sometimes may force a state either to do what the coercing state wants or stop doing what the coercing state dislikes. And Article 2 of the ACI reflects this structure, and because the EU does not treat every unfriendly economic pressure as unlawful coercion, the Commission and the Council assess qualitatively and quantitatively with the factors such as seriousness, intensity, frequency, breadth, impact on sovereignty, and whether the third state has a legitimate international concern. So it actually combines with three elements. The first one, whether it has economic merit. And the second one, it is whether it has the coercive purpose. And the third one, whether it interferes with the sovereign choice of the member states or of the union itself. This resembles a very classical non-intervention theory. It is useful as a trigger for the ACI procedure because economic coercion is a fundamental meaning. In this sense, International Court of Justice judgment in Nicaragua is still the key starting point for assessing and understanding unlawful intervention. The court made it very clear that intervention becomes prohibited when it is coercive. And when it interferes with choice that should remain within states' own freedom, such as political system and economic system, or international relations. At the same time, the case does not mean that every form of economic pressure can automatically amount to unlawful intervention. Moreover, as I said in this key implication, the EU's funding or economic pressure under EU law does not automatically prove that the other state has committed an internationally wrongful act. So this gap between EU law and international law requires a more structured assessment. And in this paper, I propose with 7 steps for this union responsive measures. So at first, it's very necessary to identify the concrete URE measures because sometimes it can be retortion, it can be unlawful countermeasures, and sit in the middle is the countermeasures. And we have to assess with a more strict standard. Countermeasures are otherwise unlawful acts whose lawfulness may be precluded only under strict conditions. And in this part, the collective dimensions is especially difficult. So we can see from this slide, Article 48 or ASEVA allows non-injured state to invoke responsibility for certain serious breaches owed to a wider group. But it does not clearly say that the non-injured state has a right to adopt countermeasures. And Article 54 leaves this open by referring only to lawful measures without identifying what the measures could be and when they are permitted or what limits apply. So this is the gray area in which the ACI becomes legally interesting. To adopt the legally union responsive measures, so it should be satisfied with the criteria with attribution, injury, purpose, and necessity. In this sense, the ACI does not erase uncertainty surrounding collective countermeasures, but it may be understood as a regional attempt to manage the uncertainty through institutional procedures and legal constraints. As I put it on the third point, says the ACI operates at the boundary between EU institutional law and international responsibility. So I think the ACI's answer is best to presumed as a continuum of a justification. So 3 hard questions follow. Since we have very limited time, I will just briefly talk. The first one is attribution. Because ACI's definition of economic coercion covers informal, disguised, and silent coercion, that will require legal proof to connect that behavior to the state, not by just politically dislike. And the second one is the injury. So the question of collective injury is more complicated. If the prohibition of intervention protects a collective interest, potentially of an erga omnes character, so the EU has a strong basis for responding on behalf of the targeted member states. If coercion targets a policy choice of union itself, the EU has a more standing. So if it targets against the member state, I think the EU must explain, whether it satisfies with the EU interest, whether it affects EU trade competence. And third one is the WTO law, because sometimes where the EU response itself breaches WTO obligation. So the general countermeasure requirements under ASEVA cannot simply bypass DSU Article 23 and the special structure of WTO dispute settlement. So the lex specialists cannot be ignored when we look into the ACI itself. And so the last one is the conditional continuum. This is why I frame the legitimacy of ACI is conditional. It bases on whether when EU takes the union responsive measures, whether it can clearly show there's wrongful coercion and attribution is established or union interest explained. This way, I want to show more like the legitimacy does not collapse because EU response. It collapses when the response exceeds its justification. So it's better to assess from the perspective of the continuum of legitimacy. And here I have 3 conclusion parts. The first one is economic coercion is a gateway concept, not a complete legal justification. It helps identify the conduct that may activate the ACI, but itself does not answer the international question. And second is ACI's novelty says and lies in institutional defense through trade law procedure. It turns a geopolitical problem into a legal design. And so the third one is my strongest defense of the ACI is its conditional justification. It needs to fulfill the wrongful coercion, legal injury, necessity, proportionality, and review. And at last, I want to say the ACI's promise definitely is not to create coercive counterpressure, but its promise lies in imposing legal discipline on defensive action. And thank you very much for your attention. I'm very open for any comments and critiques. Thank you.